of 84. Come by. Let's be friends.
A lot of things going on. Just wait, and something will be added to the mix of what is going on legally when it comes to the NCAA college sports, and really a lot of things. Supreme Court yesterday unanimously affirmed a ruling on Monday. A 9-0 vote provides for incremental increase in how college athletes can be compensated and might open the door for future legal challenges that could deal with a much more significant blow to the NCAA's current business model. We're now joined again by a professor at Baylor, Daniel Hare, Baylor Sports Law, joins us on SicEm365 Radio with Craig Paul and David Smoak. Daniel, thanks for your time. We appreciate you for being a part of the show. We see the ruling, everyone, oh my God, but what in the end, what did yesterday actually mean for now?
Yeah, thanks so much for having me on, guys. I really appreciate it. And, that's the great question, right, is that it's hard to sometimes parse this out and know what are the practical implications of something like this. And I kind of had three big takeaways as I read through the opinion over the last couple of days. And one is, it was a very narrow opinion in terms of what was actually being ruled on in this case. In other words, by the time it got to the Supreme Court, we had carved out a number of things already. So really all the NCAA or all the Supreme Court was ruling on are these educational related benefits, things like computers and tutoring and grad scholarships and other things, are those allowed to be prohibited by the NCAA as additional expenses that are impermissible? And the court says no, that they can't do that anymore. When this case started at the beginning, it was about much more than that. It was about all types of financial aid and compensation, kind of the old, should we pay to play thing. That was not on trial here at the Supreme Court level. The student athletes had lost that at the trial court and chose not to appeal it to the Supreme Court. So it was a very narrow ruling in that sense, but only because that's not what was in front of the justices to hear in this argument. But the bigger picture is we hadn't had a case at the Supreme Court level since 1984 on antitrust with the NCAA, and it was as you said, that the NCAA is subject to antitrust law. The NCAA has been arguing for 45 years that it's not subject to it at all, that it can do what it wants because of amateurism, because it's not a commercial enterprise, quote unquote. The Supreme Court thoroughly rejected that yesterday and said, no, you're going to be subject just like any other industry, just like any other organization. You cannot unreasonably restrain trade. You can't price fix. And in this scenario, you did that, and so you have violated the law. So what does that mean? It means that as the NCAA is looking ahead to other policies and other changes they need to make, they have to know they are going to, every time that they do something or don't do something, it's going to be subjected to this heightened scrutiny, and they're likely to lose on a lot of these things. And so that's the bigger takeaway from it. And of course, then the biggest quotes that you got out of the day yesterday were from the concurring opinion, which is not the primary opinion. It's not the law that's going to apply it, but Justice Kavanaugh wrote a concurring opinion that really took the NCAA to task. While the majority opinion was very narrow, very methodical, just sort of took what was given to them and knocked it down one by one, Justice Kavanaugh really went wild with kind of the big picture of the NCAA is going to lose a lot of these cases, and the pay-for-play stuff is likely to fall if it's brought before us next time.
Is the problem that the NCAA has legally, Dan, that they are they've been arguing this for 45 years, and 45 years ago, they probably had a more reasonable argument that they had a different model. But in 2021, that has changed so drastically that they need to move on past that and see where they really are.
That's a great comment and a great question, because Justice Gorsuch, in the opinion, Justice Gorsuch wrote the opinion, he walks through that, and he talks about how when you're doing an antitrust evaluation, you have to look at the facts on the ground and the current state of the industry and the market. And I think that's exactly right, that in the past, that it may not be the case that the ruling was as it was today or yesterday. But as college athletics has grown, as it's become much more commercial, as there's so much more money involved, that matters. It matters. And it's not something that you just fix in time. The Yale versus Harvard boat race from the late 1800s that was the first quote unquote collegiate athletic event. No, you have to look at where things are today. And as I think he wrote in the opinion, Justice Gorsuch talked about how there's a lot of people making a lot of money off of college sports, and certainly a lot more than the student athletes that are generating much of this revenue.
What do you think the NCAA has just kind of let decisions happen? Like, it doesn't feel like they put up much of a fight, but what kind of, how could they react to where they don't go more of the way of being a professional league and stick more to the amateur side of things, although amateur is obviously not going to be the term used at this point. And I don't know if that makes sense, but how is this going to feel like college athletics and not pro sports in the future, or is it going to feel more like pro sports?
Yeah, it's funny because I think that Justice Kavanaugh addressed that to some extent in his concurring opinion, and he talked about how, if you start to allow more of this pay for play in whatever form that is, if it's the NIL stuff, if it's something else, then there are going to be issues that get raised that are problems. I mean, what do you do about the non-revenue sports? What do you do about Title IX? What do you do about, are there salary caps like you have, or compensation caps at all, or is it a total free market? What it comes down to is he says, look, those are all problems. Yes, but you can legislate these things. You can collectively bargain these things. It doesn't change the fact that the current system is illegal and can't continue. So you have to figure out something. And so, I think, and the other thing that they talked about, both justices talked about, which I thought was interesting, is, to your point, using amateurism or amateur as a way to describe what is unique about the college product. And that's really their whole argument, right? Is that the fact that they are unpaid amateurs is what distinguishes college athletics from professional athletics from the standpoint of the consumer. That's always been the argument. And so therefore, if you start paying them, the argument is that it will look nothing more than like a minor league professional system, and it will ruin the sport. It will ruin the product. And antitrust law is supposed to balance this out. You don't want to take away or diminish or ruin the product. But as the justices said, you can't wrap up within the definition of the product something that is illegal, like price fixing, restraining wages is simply illegal in any other industry. And they go through it and talk about, I love this from Justice Kavanaugh, where he talks about how, if you get a bunch of restaurants together and cut the cooks' wages on the theory that customers prefer to eat food from low-paid cooks, or if you get law firms that conspire to constrain their salaries and just providing legal services for love of the law, you can't create a whole product system around that and call it good. And that's what the NCAA has been trying to do. So, I think they have a tough road ahead to try to distinguish the product from professionals, but at the same time, I think they're going to have to do it. And so, the NIL side of things, which is separate from this, although they're connected, it's separate from this. But certainly that seemed like the layup that they had 10 years ago to try to make headway here. They haven't done it, and they're up against it on that issue as well.
Daniel, do you have you ever seen much? And I don't keep up a lot of the Supreme Court decisions. Sometimes it's way over my head, but I keep up with some of them. But have you ever seen a judge, a Supreme Court justice, come out like Kavanaugh did and just blast someone? I mean, is that kind of rare?
So it's funny because what tends to happen, honestly, is it comes in situations like this, or often it comes in the dissenting opinion. This was a 9-0 decision, so we didn't have a dissenting opinion. But back when she was alive, Ruth Bader Ginsburg was well known for her dissent. And as was Justice Scalia before he passed, when the majority went a different way from him. And so he would have some pretty salty words in his dissents as well. So it's sort of similar here because you have this concurring opinion from Kavanaugh, which isn't the primary opinion. It's not binding law, although it's certainly going to be persuasive on a lot of folks. But no, it's not that uncommon to see in a concurrence or in a dissent some spicy language from one of the justices. Not at all.
NIL has a week before it goes into effect, essentially. Dan, and the NCAA has done nothing. They've begged Congress to do something, and that's like, two people without hands trying to pick up a ball. When it comes to that, what do you think they can do when it comes to the fact that there's going to be 6 states and probably more rapidly as soon as they can get bills passed doing this, and the NCAA just sitting and waiting for Congress to do something?
Yeah, it really just does. I mean, it just kind of blows your mind to watch. I mean, the O'Bannon case went on for 10 years, basically, on this subject, and they lost. And they still have not figured this out. And to then put it on Congress at a time like this, is just another mistake. I mean, not that they don't need some type of national legislation, but that's what the NCAA is supposed to be for. I keep laughing at this idea of, well, we need a national standard. Yeah, that's what you're for, NCAA, is the national standard. If it hasn't worked, you got to fix it. Don't go to Congress. You're the national standard. But yeah, you're right. You've got 6 states here on July 1st that are going live with NIL programs. 19 more states have passed some version of NIL. Oh, by the way, Texas is one of those 6 that are starting here in July. And so, Congress has already said they're not going to get a bill, at least until the fall. But I think that's even optimistic with everything they've got going on. So, I think we're going to have this patchwork system. The Division I Council is meeting today and tomorrow to discuss what they could do. They were, I think, also waiting to hear from the Supreme Court to see how that might impact what they decided to do. And I think we're maybe expecting to see something on Monday or Tuesday next week, a vote of some kind on this, but it's going to be, probably temporary and pretty patchwork that's going to allow these 6 states to do what they're going to do, and then allow the other 44 to come up with their own either version, or schools within those states to come up with their own version of NIL until there can become a national standard. And, it's not ideal, but, at the end of the day, is everything going to fall apart? I don't know, but that's where they painted themselves into this corner. And that's where we're going to be.
Daniel Hare is a sports law professor at Baylor University on the NIL, the name, image, likeness, also the Supreme Court ruling. So to kind of just calm the waters a little bit, you could see this is coming down the track. Craig made some comments and opinions yesterday about athletes now, how much they do get. There was a time, and I'm 62 years old, get off my lawn, my God, they get a free education, whatever. But it seems like it has flipped the complete opposite. With all of what they get, that's fine.
And this is more name, image, likeness that they're talking about. So
right.
This is just the ability to make money off your name is really it. But yeah, tens of thousands of dollars are spent on each student athlete every year, not counting tuition. Yeah.
Yeah. And all the things as far as tuition board, whatever. But this is not a ruling yesterday. Do you feel like, Daniel, they'll ever just be able to say, and some schools are probably doing a pretty good job of this anyway, here's an envelope, like the Mafia, here's $10,000 for a running back or $150,000 for a star quarterback. You don't think it'll ever get to that legally, do you?
It's hard to say, honestly, at this point, because to your point, and actually in the opinion, Justice Gorsuch walks through this as a rationale for why this amateurism status or amateur deal is so amorphous, because he talks about how, at the beginning, it was exactly as you say, Smokey, that they would pass envelopes to folks and pay for players to move schools and move teams, in the early part of the 1900s. And that's how it was. And so when the NCAA came along and started to, legislate some of this, it was, okay, now we're going to pay for tuition. That was in the 40s. And then in the 50s, we increased it to include room and board. And then in the 70s, we said, okay, if you're a professional in another sport, you can play college in a different sport. And then in the 2000s and 2010s, we said, okay, now you can have full cost of attendance. And so it's continued to move and move and move. So what is, and at any point, have we seen a diminishing of popularity of college sports? I think most people would argue, no, we haven't. And so the idea that somehow, those incremental increases, to think that they would stop, moving forward, I think is a mistake. I think they will continue. And so you are running out of the creative little ways to add on more things, aside from the fact that, okay, we're just going to say, we can pay the players. I mean, that's kind of where we're almost out of the creative ways to compensate. Yeah.
Daniel, tell us about your podcast.
Well, I've got several. So, my podcast is for the lawyers out there, and so people can check that out if they want. But people for sure can follow me on Twitter at Daniel Hares, where I talk most about this stuff these days, and happy to engage with people there. It's an interesting time for sure, and this is a busy summer with all this. Supreme Court opinion and NIL stuff happening all at once. So I appreciate it, and would love to hear from folks.
All right. Hey, Daniel, good stuff. Thank you. We'll might be tracking you down as things continue to move forward, whether it's NIL or anything else with the NCAA. Thanks for your time. It's Daniel Hare. Appreciate him jumping on today. Mac Rhodes, by the way, will be tomorrow at 4:20. He could not make it today. It's been 3 or 4 weeks, and look forward to that segment with the AD at Baylor, Mac Rhodes, tomorrow.
You know, if you took the revenue, not from last year because it was well under $1 billion because of, all the things that were canceled. If you took the revenue from the last, regular year of the NCAA, which is a little over $1 billion, and you divided that by the number of college athletes right now, each college athlete with all the revenue, that's not taken out to go pay for actually the stuff you got to pay for. Take the amount of just pure money made, and you divide it by every athlete in college athletics right now based on the number I saw. Each athlete would get $2,500. $2,500.
Yeah. So that's why
that's the revenue. That's not taking out
net. Bowl. No. Yeah. That. I mean, I think that's I looked up NCAA revenue.
Yeah, because aren't there 5,500 or 8,000 college athletes?
Yeah, 2019 it was a little over $1 billion. It was between 1 and 1.25 billion, and then last year it was barely over 500 million because of COVID. But it's been steadily rising, and so in 2019 it got to its highest level, but there's 500,000 student athletes in college in America. Yeah. Now you're counting all levels obviously, and only one with two whole sports on one single level. All of college athletics, 2 sports on one level actually make money. But if you encompass everything, there's 500,000 student athletes in the country, give or take. So if you take that and you didn't take any of the money away from the pot, each athlete would get $2,500.
That's why I think the NCAA should have been way more out on NIL, because if they kept if they say pay the players, you're paying the coach $7 million at some places. Maybe Saban's going to be at about 10 by the end of this contract that he just signed. It's fine, but instead of the schools paying the players and divvying up that money, which again, like you said, you get in all these Title IX issues and why do they get more even though they make more and blah, 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 and get out of the weeds. Just let the players go make money on their own. Yeah. NIL is not going to take any money out of the pocket of the NCAA. No. As a matter of fact, in certain instances, it might increase it because now you have a double whammy of investment. So
I'm curious, can they get sponsorships? What if, this is a thought I had last night. What if you're a guy who plays for a Nike school, but Adidas says, hey, we want you to do commercials? How does that work?
Well, I think the one thing I'm concerned about that would be the other way around, especially with basketball. Yeah. Where it's essentially what they've done is they've made everything, we talked about this the other day, they've made everything that used to be cheating legal because now there's paperwork for it. Big Red Motors, they can have cars and they can work here as promotional people. They can be endorsers, and Rhett Bomar didn't have to, have somebody clock in for him while he's taking a nap. Greg Hill, you remember Greg Hill, same thing at A&M, so all those things that happen, those can be legal now because they can be compensated endorsers. What I am worried about, though, is you look at the Nike or the Adidas scandal, what they were doing was funneling people to schools.
Yeah.
Well, what's to stop that from happening? Now, that's a small scale because you're talking about probably 15 guys a year who really would qualify for that kind of high-level recruit that you'd want to push your shoe. But what if they say, okay, you're signing with Adidas, you can go to Kansas, you can go to Notre Dame, you can go to these are the schools you can go to, and then you have to, and of course if you're the athlete, you have to understand that if I'm making this agreement with Adidas, I'm taking this money, and I might not be going to a school that I may want to go to because they're Nike, or vice versa.
I'm getting a headache.
Yeah.
It's a complicated big old ball of twine.
Yeah, I'm wondering who's going to be the first business to just screw up the whole thing by making it way too high of an offer, and then everybody's got to that's what I start thinking about. I mean, it's not my concern really, but who's the first dumb business that's like, let's go all out, and and then it just sets this bar that's going to be hard for
to bring back.
I mean,
the transfer portal. Look where it is now compared to where it was. Right?
Exactly. But who's the business that's going to go all out for Garrett Gilbert?
Yeah.
And then he winds up at SMU and not worth. I mean, look, he's a good player.
So let's say you give him $100,000 to go to. I'm just using Garrett Gilbert, $100,000 to go to Texas. He could have gotten whatever the demand would have been. He got it.
He should have owed.
Then he ended up leaving. Does he still? Is there a tie-in? You got to stay. Do the businesses?
Yeah.
You have to be here 4 years to get that money. It's $25,000 a year.
But the market always corrects itself.
I know.